evening and welcome to Reach Lawyer's Friday Talk series on beleaguering labor. Today's discussion will be a freewheeling discussion on the decimation of labor rights in India. Today's discussion is also the fourth in a series of discussions called How to Kill a Law. And as the name suggests, these discussions will seek to understand why there are concerted efforts today to undermine important legal safeguards. But before we move on to today's discussion, I'd like to take a moment to briefly introduce to you what Reach Lawyer is. We are a network of lawyers concerned about rule of law, constitutional morality, and broadly the future of this country. Simply put, Reach Lawyer is a legal training and support initiative for civil rights movements, social activists, and individuals to empower them with legal knowledge. While the core of activity revolves around our work with the legal fraternity, we also undertake various other initiatives to further legal awareness, social legal advocacy, and perhaps most significantly, we collaborate with various human rights groups and grassroots organizations across the country. To know more about us, you can look us up at www.reachlawyer.org. Before we move on to beginning today's discussion, those of us at Reach Lawyer would also like to remind those watching and ourselves that there are farmer-led agitations going on across the country. These are issues that affect an overwhelmingly large section of our population, and any effort at us being concerned citizens has to involve us showing solidarity, expressing our solidarity with these movements, and engaging in sustained conversations on issues like the anti-farmer bills and the undemocratic way in which these bills were rushed through Parliament. With that, I'd like to hand over today's discussion to our moderator, Main Mavra.
A very good evening to you all. Welcome to Reach Lawyer's Friday Talk Show. Today's episode is on beleaguering labor, which is a part 4 of our series, Floyding, How to Kill a Law. Today's talk is a dedication to the entire labor force that forms a backbone of our country and its functioning. I am Main Mavra, and we are going to discuss on the notion of decimation of rights of the labor. Now, before we begin, it's imperative for us to get an idea about the history of labor laws in our country in order for us to understand and acknowledge the condition of the labor force in India today. Now, the history of labor legislation in India is naturally interwoven with the history of British colonialism. Considerations of British political economy were naturally paramount in shaping some of these early laws. In the beginning, it was difficult to get enough regular Indian workers to run British establishments, and hence laws for indenturing workers became necessary. This was obviously labor legislation in order to protect the interests of the British employers. In that period, cotton mills, jute mills, and coal mines provided employment to various workers. Nearly 700,000 workers were employed in modern factories, worked by mechanical power alone. This early phase of industrialization was marked by inhumane exploitation of the workers, who were paid a mere pittance and made to work for long hours in insanitary conditions, with hardly any provision for periodical rest or prescribed holidays. Professor Bipin Chandra gives a brief sketch of the working conditions of this period in the following words. He said, generations of English workers and the early generations of Indian men, women, and children working in modern industries were subject to as ruthless and revolting fit of exploitation as known to modern man. Now, the labor movement has been instrumental in the enacting of laws protecting labor rights in the 19th and the 20th centuries. Labor rights have been integral to the social and economic development since the Industrial Revolution. Labor law, therefore, arose due to the demands of workers for better conditions, such as the right to organize and the simultaneous demands of employers to restrict the powers of workers' many organizations and to keep labor costs low. Employers' costs can increase due to workers organizing to win higher wages or by laws imposing costly requirements such as health and safety or equal opportunity conditions. Now, the plantation industry in Assam was the first to attract legislative control, and a number of acts were passed from 1863 onwards. Bombay was a pioneer in the formulation of legislation on labor. Some form of trade union organizations came into existence after the establishment of factories in India in 1870. The Indian Factory Act was enacted in 1881, in which employment of child labor was prohibited. As an organized movement, trade unions began to take shape in India in the years immediately following the First World War, when there was an outburst of industrial strike. The rise of trade unions was a new development in the society. Trade unions are essentially the product of modern large-scale industry. Indian trade unions did not grow out of any existing institutions in the society. In fact, they developed as a new institution. So far as the question of formation and development of trade unions in India is concerned, its necessity was realized from 1875 onwards by philanthropists and social workers like Shri Sorabji Bengale and Shri N.M. Lokhande. As a result of their concrete efforts, there was awakening among the workers, and they had formed a few trade unions like the Printers Union in Calcutta, the Bombay Postal Union, etc. However, the very first union was started in Madras by the initiative of Mr. B.P. Wadia in 1918. It was known as the Madras Textile Union. Now, after the First World War, labor legislation took shape at a rapid rate. The reasons generally ascribed for this accelerated pace are many. All labor legislations in India under the Government of India Act 1919 were enacted by the central legislature. In India, there were a number of labor laws which were applicable in different sectors and there also existed many trade unions. Now, in 1920, in Ahmedabad, an association of workers was formed which developed into a model union. It was unique in its constitution and its leadership. Under the guidance of Mahatma Gandhi, the Ahmedabad Textile Labourers Association was able to build up a solidarity among the workers which was unrivaled. The union was one of the strongest in the country. The chief importance of the union lies in the fact that it had devised an elaborate system of joint conciliation and arbitration with the Ahmedabad mill owners, by which this textile center has been almost free from strikes. Now, the year 1920 also saw the establishment of the All India Trade Union Congress as a central organization of labor. It was established as a result of a resolution passed by the organized workers of Bombay and the delegates which met in a conference on October 1920. The main impetus of its founding was the association of India with the International Labour Organization. The passing of the Indian Trade Union Act of 1926 conferred a legal and a corporate status on registered trade unions and gathered them certain immunities in regard to trade disputes. In 1919, the International Labour Organization was founded, and for the purpose of sending representatives to the organization, the All India Trade Union Congress was started. Lala Lajpat Rai was elected to attend the conference held at Geneva, and later on in the first meeting, he was elected as its chairman. This year, the AITUC, in fact, celebrates its 101 years of its establishment. In the 1929 Imperial Government of Britain constituted the Royal Commission on Labour in India, with the express mandate to inquire into and report on the existing conditions of labour in industrial undertakings and plantations in British India. Recommendations under the Commission led directly to most of the legislation being passed from 1931 onwards. Soon after the Industrial Truce Resolution was adopted. The resolution called upon labour and management to maintain industrial peace and avert strikes, lockouts, and slowing down of production for a period of 3 years. As an additional measure to solve the disputes between the employers and workers, the tripartite and bipartite machinery of the Labour Conference was played its part. Now, while speaking about the labor movement, the topic would be incomplete without mentioning the contributions that Dr. B.R. Ambedkar made to the movement. In August 1936, he formed the Independent Labour Party and drew up a comprehensive program which answered all the immediate needs and grievances of the landless, poor tenants, agriculture, and industrial workers. He was deeply concerned over economic and social exploitation of depressed classes, particularly the labor class. He also presided over various conferences in furtherance of solving labor issues. Eventually, the Industrial Disputes Act 1947 was passed and implemented. With time and with growing demands for protection of labor rights, various state and central labor laws were enforced in the country. Recently, the Indian Parliament decided to codify over 40 central labor laws into 4 codes, in order to simplify the plethora of existing labor laws and combining various contradictory laws within these codes. Now, these codes center around industrial relations, occupational safety, health and work conditions, social security, and wages. While supporters of the codification uphold the simplification of laws and various provisions helping in employment generation, critics raise concerns that the codes are more pro-employer rather than protecting workers under the unorganized sectors, among various other criticisms. Now, in order for us to get a clearer understanding about where the rights of the labor stand today, especially since the introduction of these new labor codes, we have with us today two eminent speakers. To start off with, Professor Babu Mathew, who barely requires any introduction. He's a great trade unionist and eminent professor of law and mentor, and chairperson of the Institute of Public Policy. His work as a trade unionist across industries from the public sector to the unorganized sector, as well as a teacher, has been really inspirational. Joining him in giving us the concluding remarks will be Advocate B.T. Venkatesh, who is a founder of Reach Lawyer, a human rights lawyer, and a former state public prosecutor in the High Court of Karnataka. It's truly a privilege to be hosting both of you today. Now, I shall open the floor for questions to Professor Babu Mathew. Sir, to begin with, for the benefit of our viewers, could you please give us a brief of the 4 codes that have been passed by the Parliament recently, and what is it that they entail? I now invite you, sir.
At the very outset, I must congratulate Reach Lawyers and young colleagues who have invited me to this program. Main Bavara, you have already done a fantastic job. I wish you would avoid experts like me, because already I feel that your expertise is good enough and you ought to have carried the program forward. But however, since I've accepted the invitation, let me begin by engaging with your opening questions. Indeed, the attempt of the government of India to bring together this massive body of labor legislation is an unprecedented exercise. Of course, they call it simplification. I'm not very convinced that it is simplification. If you look at any one of these codes, whether it's the Industrial Relations Code, or the Wages Code, or the Social Security Code, or the one dealing with occupational safety, you notice that they all begin with definition clauses. Those of us who are familiar with labor law, we know how much of time the Indian Supreme Court has had to spend on figuring out the meaning of some of the definitions. For example, in the Industrial Disputes Act, there is the definition of the word industry. It has been said that if you plot the Supreme Court judgments on a graph in relation to the word industry, then you will get a zigzag curve. That's been the effort to define one important word in the Industrial Disputes Act. Some of the statutes have exhausted the alphabets while defining clauses. Twice over, you have crossed A to Z once and A to Z again, and then gone through the other half in the third time you're attempting to go through the alphabets. That's the length of the definition clauses. And I am quite sure that when litigation begins, then it will be quite an uphill task. I'm saying this only as one example to say that it's not simplification. Moreover, when the courts laid down case law in respect of a particular statute, when you bring together statutes, will that case law be valid? In many cases, it will not be valid. You will lose a rich treasure of labor jurisprudence, which courts and trade unions and managements and labor departments have struggled in order to evolve. So I suspect that these laws will play a hugely destabilizing role, not a simplification role. Yet, let me take a few minutes to try and capture some dimensions of what these laws do. If you take the Industrial Relations Code, it not only brings together the Industrial Disputes Act, the Trade Union Act, and the Industrial Employment Standing Orders Act. And the major effort of the Industrial Disputes Act, as was already indicated by mine, is to bring about a settlement of disputes. There are many methods for settlement of disputes which are envisaged in the old Industrial Disputes Act. But when it comes into the Industrial Relations Code, there's a tremendous downplaying of collective bargaining. Let me emphasize that as a major shift in Indian labor law jurisprudence. When the Prime Minister is talking of Atma-Nirbhar or self-reliance, it's important to note that self-reliance can be achieved only when workers voluntarily cooperate and feel that they are part of the industrial enterprise. And that has been achieved in India through collective bargaining. I myself had the opportunity to sign scores of collective bargaining settlements. If you look at the city of Bangalore, every good factory in Bangalore has had several collective bargaining agreements. And that is how industrial peace is ensured. Workers get a better wage. Workers get better working conditions. But the management gets industrial peace. They get higher productivity. There is quality in production. And that is how industries pick up. So the Industrial Relations Act, the Industrial Relations Code, which replaces the Industrial Disputes Act, is losing out because it de-emphasizes collective bargaining. You know that a trade union can exert its pressure only when the management is afraid that workers may go on strike. But here is a law that removes the ability of workers to go on strike through very clever provisioning. If you look at the Trade Union Act itself, I must acknowledge that one good thing which this codification has brought into effect is there will now be compulsory recognition of trade unions through the central legislation. That's welcome. And they have also agreed that you can have either a negotiating agent or a bargaining council. If a negotiating agent gets more than 50% of the votes, that will become the sole negotiating agent. And if nobody gets that, and there are many trade unions, they'll come into a bargaining council. This is welcome, but there is a hangover of the past. And that is a hangover which unfortunately this government has inherited from the thinking of the Congress-led INTUC. And that is, they don't want to say that recognition will be carried out through the use of the secret ballot. Instead, they have left it to the appropriate government. There's one phraseology which is continuously used in all pieces of legislation, and that is the phrase, as may be prescribed. In other words, instead of the legislature articulating the policy on many important things, they have left it to the legislature. If in the old Trade Union Act, if the trade union breached the law, then it would be confined to the breach of some provision in the Trade Union Act, let us say, not filing the accounts in time. But now, if the trade union defaults in terms of the procedure laid down for strike, then the government can come down and cancel the registration of the trade union. This is a new and negative feature. It goes against freedom of association. What is the point of freedom of association if the registration of a trade union can be cancelled? Why do you give registration of a trade union? To achieve immunity from civil law, criminal law, and tortious law. Immunity of a limited type, no doubt, but 3 types of immunity. If you cancel a registration, then you lose this immunity. So in other words, there is a lot of apparently good things, but you do a deeper reading and you find that it's quite problematic. You must tell me, in similar manner, do you want to go through the other 4 codes? Because these codes are so exhaustive in nature that even attempting to summarize it takes a long time. I would come back to you to ask whether you want me to, in similar fashion, deal with the other 3 codes before we proceed further, or would you have some other suggestion? Let me pause and hear from you.
I think that'll be great, because I think the idea behind this is to let the general public know the idea behind the codes, because they are not aware what they are. So I think it'd be great if you could share their insight.
Okay. And you please feel free to intervene even in that process, so that this doesn't become too monologue-like. Anyway, I'll now, taking a clue from you, I'll proceed to look at the wage code. The wage code also is quite an innovation in terms of bringing together, on the one hand, the existing legislation relating to the Minimum Wages Act, relating to the Payment of Wages Act, relating to the Bonus Act, and relating to the Equal Remuneration Act. So these laws are brought together. Let me highlight to you that the Minimum Wages Act is an extremely important piece of legislation. And that's the right place to introduce into our conversation the informal sector. Minimum wages classically is something that applies to sweated labor. What is the meaning of sweated labor? I think the idea that there are laborers who have to live literally out of the sweat of their brow, hard work, under the sun, under very difficult conditions. There are people who are not organized, and the employers will exploit them to the maximum. And therefore, as early as 1948, it was decided to have a special legislation for them called the Minimum Wages Act. And along with that is the Payment of Wages Act. It's an attempt to make sure that what is due to the worker by way of payment of wages is promptly given. It should be given on a particular date. There should be no illegal deductions. There should be no harassment of workers in relation to wages. When they have finished a month's work, their wage should be guaranteedly and paid to them. Equal Remuneration Act, we know that in this country, even though we proclaim equality in terms of constitutional rights between men and women, in reality, women are always underpaid, even though they may be doing the same type of work. Why same type of work? Very often they do work which is much harder than the work that men are doing. Take agricultural laborers. It is women who have to continuously keep their backs bent and do all the difficult work. And yet they will be classified as unskilled workers. Not only that, if there is a comparison between an unskilled male worker and an unskilled woman worker, invariably this unskilled woman worker will get lesser. Even if the law prescribes equality, that is not the case. That's always denied. And then if you look at the Payment of Bonus Act, it's important for me to use this opportunity in order to say, at first glance, it may appear that this law has nothing to do with wages, but there is a constitutional provision which attracts our attention. The Constitution says everybody must be paid a living wage. Please imagine a pyramid. At the bottom of the pyramid is the need-based minimum wage. At the top of the pyramid, at the apex of the pyramid is the living wage. And in between is the fair wage. And so the constitutional vision is that over a period of time, every worker must be entitled to a living wage. But in India, a very hopelessly small proportion of even the organized labor will be close to the living wage. And therefore, in order to bridge the gap between the wage that is actually drawn and the wage that the Constitution promises, that's the wage between what you receive at the end of 1 month and the promise of the Constitution. To bridge that gap, bonus is considered to be an annual payment. Its understanding is through the work of laborers, profits have been created. Let the employer take a part of this profit and share it with the workers. So that is the reason why the Payment of Bonus Act is also brought into this wage code. Let me then point out to you, the most glaring issues in relation to the wage code. The wage code has within it a mechanism for prescribing minimum wages. Part of it is borrowed from the old Minimum Wages Act, but a part suddenly disappears. You know that under the Minimum Wages Act, if you ask the question, who is entitled to minimum wage? Only those who belong to scheduled employments. And so the Act would schedule a particular employment. And in this manner, across India, from the year 1948, 2,000 employments have been scheduled. Suddenly, in this code, scheduled employments have disappeared. That is going to create confusion in the days to come. And so, the minimum wages, it is said, can still be fixed by the appropriate government, which includes the state government. They have the power to fix minimum wages, but the scheduled employments have disappeared. That doesn't mean that they cannot fix minimum wages, but I'm quite sure there'll have to be creative application of jurisprudence in order to achieve this. And I hope the state governments will wake up to this challenge. But there is a more important part, and that is what should be the amount of money to be paid as the minimum wage. Even the old enactment was silent on this question, and therefore the Supreme Court came down and laid down the principles on which minimum wage should be fixed. And I am happy to mention to you that the most important case in this regard was a case presided over by Justice Gajendra Gatkar. He's been considered one of the doyens, a legal luminary of great eminence. So he presided over a constitution bench, and that is Unnichoy versus State of Kerala. And it is in that judgment that the Supreme Court laid down that wages will have to be fixed in accordance with the 15th Indian Labour Conference. That is a conference in which management, trade union, and government came together. And for the first time, they were asking, how shall we quantify the minimum wage? And so they had to take the services of a nutrition expert by the name of Dr. Aykroyd. And Dr. Aykroyd came on with the agenda papers and said, every individual who is concerned with moderate activity, moderate, not even heavy activity, moderate activity would require 2,700 calories of food grains in order to be able to work with certain minimum amount of efficiency. And so I won't, it'll be too much of detail to go into all the elements of that 15th Indian Labour Conference. But I can say that if you strictly follow the 15th Indian Labour Conference, I've tried a few years ago in the Nagarbavi market. If you calculate it, the wages will be nothing less than 18,000 rupees. So if you apply it to today, it will be about 20,000 rupees if you use the norms of the 15th Indian Labour Conference. Now, in that scenario, how the wages should be fixed was left to the rule-making power. I must say that this is not good law. That amounts to abdication of essential legislative function. And when that happens, the Supreme Court strikes down the legislation. It is excessive delegated legislation. Policy matters cannot be taken over by the administration. That's the job of the legislature. Yet they have done that. I have well in advance circulated the opinion that you are inviting judicial intervention and writ petitions will come. Yet that is what has happened. And the other part which is worrying is a new type of wage has been introduced, and that is the floor wage. The idea of a floor wage, if it is well conceived, it can be a good idea. But the floor wage, what function should it perform? The floor wage should be something which will pull upwards all other wages. But there is the danger that if you don't fix it properly, it will pull downwards all other wages. It can become a drag. And the Union Labour Minister, when this code was passed, he announced that the floor wage will be 198 rupees. That's a pittance of a wage. And the ministry had appointed an expert committee. And that expert committee said it should be 375 rupees. Similarly, an expert committee which was examining the question of below poverty line studies, they did a calculation through another route, and they also came up with 375. If at all this government is keen that those who are very poorly paid should be lifted up, then they cannot be serious about saying that the floor wage will be 198 rupees. So that's a deep flaw insofar as this part of the legislation is concerned. Let me jump to the Bonus Act. The Bonus Act prescribes a minimum bonus of 8.33%. 8.33 is equal to 1 month's wage. And the maximum bonus is 20%, which is equal to 2.5 months' wage. Now, when you have that kind of an arrangement, how much should it be between 8.33 and 20%? How do you determine that? You'll have to examine the balance sheet. If necessary, you will have to put the finance director in the witness box and ask him questions to find out whether the balance sheet is a genuine one or a bogus one. This Bonus Act says that the balance sheet will not be given to the opposite party. How can you determine what should be the quantum of bonus if the very instrument on which bonus should be calculated is sought to be denied? So in that sense, those are examples of deep, flaws in those enactments. What do you say, Amin? Now, shall I move on in similar fashion to the Social Security Code? Or what do you feel now?
I think we can pause here for now.
Yes.
Thank you for such clarity about the legislation. I believe Saurabh has a question for you, sir.
Okay.
Saurabh, on to you.
Good evening, Professor. So, you gave us a very exhaustive understanding of the code and wages and some of the provisions of its underlying acts. Since you had brought this up in your own speech, one of the things I wanted to inquire about was this flow wage. And you've spoken about how the introduction of flow wage has its own sort of drawbacks. One of the things that was criticized about the flow wage was that it would only be revised once in 5 years. And that also importantly, the flow wage is a really bad approach to setting a minimum wage, because it's just the government essentially, like it's the same pattern of the devil being in the details. It's essentially the government saying that we're setting a floor wage, you can't possibly fall below this, but we leave it up to the states to come up with sort of better wage rates and stuff like that. So do you think this floor wage and the time that's given for it to be revised, which is every 5 years, is actually going to make the wage situation worse for workers?
Yes, that's a good question. This interface between minimum wage and floor wage would require quite a lot of debate in order to unfathom its significance. I want to be a bit balanced on this particular issue, and so I'm inclined to say it's a fact that minimum wages fixation has been slow, and as a result of it, 2,000 employments across the country have been reached since 1948. And we know for a fact there are millions of workers whose wages are far, far below the minimum wage that is now determined. Therefore, if, on considering different aspects of it, there's a view taken, okay, let us as an interim measure try and pull up the wages of all those whose wages are absolutely pittance. There are states in India where the real wage that is being paid is below 100 rupees, sometimes almost half of that. So in such cases, are you serious, first of all? Are you serious that you will implement a floor wage? What's the meaning of a floor wage? That means no wage worker in India will get below the floor wage. Whereas when it is minimum wage, what you're saying is, if you are covered by a scheduled employment and it is notified in respect of a tailor or a barber or a hotel worker or a construction worker or a quarry worker, their wage will be determined by the minimum wage. But if you're saying any wage worker in India, that person's wage shall not be below, then obviously in the Indian context, it's going to be lesser than the minimum wage. How much lesser than the minimum wage is an interesting question. And in relation to this, some scientific yardstick has to be made. Government of India's own committee, I think, pitches it at roughly half of what the minimum wage ought to be if it is calculated under the 15th Indian Labour Conference. But the Union Labour Minister's pronouncement is 198 rupees as opposed to 375. So there is no clarity in the government's mind. And you are right, Saurabh, whenever wage revision is postponed in that manner, that you do it only once in 5 years, then the real wages will get eroded. There might be some marginal movement in the nominal wages if it is linked to the variable dearness allowance. Sometimes there is no clue whether floor wage will be linked to variable dearness allowance. Minimum wage by practice is linked to variable dearness allowance. But how far it achieves 100% neutralization for price rise is another matter. So you have certainly raised an important question, which deserves careful consideration.
Professor, I think we're sort of running out of time. So if I could move on to the Social Security Code. One of the biggest criticisms for Social Security currently under the new code is that it, like you said, vests excessive, it essentially is an abdication of an essential legislative function, and it vests too much delegated power in the hands of administration. One of the ways it goes about doing that is that it specifies different threshold limits for different social security schemes, whether it's the provident fund or the state insurance scheme. And to top it off, I think one is 20 establishments with 20 or more workers, one is establishments with 10 or more workers. It also, to make matters worse, goes on to say that the central government by notification can further amend these threshold limits, which presumably means that the central government can increase that threshold applicability to say 30-40 workers also in the future. And you add that to the 2013-14 economic survey that said that close to 80% of our workforce is employed in establishments with less than 10 workers, doesn't the sum total of this impact simply mean that you can exclude almost all our laborers from the applicability of these acts?
Yes, I think the highest level of discrimination when you look at these four codes is manifested in relation to social security. There is a polarization in respect of social security measures. On the one hand, if you come from the organized sector and if you have been in an establishment which is duly qualified according to the new norms, then you will get the Provident Fund Act, you will get the Employees State Insurance Act, you will get the benefit of the Employees Compensation Act, you will get the benefit of the Gratuity Act, you will get the benefit of the Maternity Benefit Act. Why 5 enactments is welcome if you look at ILO's standards in respect of decent social security measures. You'll get it just by implementing the Provident Fund Act and the ESI Act. Enough. Between them, they cover all the minimum social security standards that the ILO talks about. So that is made available to the organized sector. Please notice that the organized sector is 7% of the workforce of 500 million. And so their social security is somewhat protected. But as for the remaining, as you have already hinted, they are not guaranteed any of these social security measures. Instead of that, they are given another treatment. The informal sector social security is a strange picking and choosing from all the anti-poverty measures, for lack of a better expression. There's a pension scheme here, there's a maternity benefit scheme there. And so these miscellaneous things are brought together. And even for that, there is no resources. Whereas for the organized sector, there is a method and there are resources by which you can protect it. That's welcome. I'm not unhappy about that. I'll be unhappy if they begin to dismantle even that, as they are already attempting to. But so far as the informal sector is concerned, it's left to the state government to find the resources. Where will they find the resources from? And those state governments which have tried some innovative methods to create welfare funds and welfare boards, like the Construction Workers Welfare Board, that is now sought to be dismantled. In Kerala and Tamil Nadu, there are more than 20 welfare boards which were running without the help of the government of India. And that is sought to be dismantled. So you have a strange kind of discrimination on social security measures between the formal organized sector and the informal unorganized sector. And there is no serious protection. If you are serious about it, it's a straightforward matter. Please just make the Provident Fund Act and the ESI Act applicable to the entire informal sector. Then they will qualify for the minimum needs that the ILO has already mentioned. But you'll have to find the money for that. And then what do you do in respect of those who are self-employed, those who are not wage workers? Where are they going to get equal contribution from? They don't have an employer. And so you will have to find a different method in order to raise resources. So the question of social security cannot be tackled in an ad hoc manner unless you take up the total universe of the workforce in India and you determine what's the minimum social security, and you also determine where is the money for it going to come from. If you keep making concessions to the super rich and allow them not to pay the taxes, then where are you going to get the resources? Still, I think there is that lack of clarity in order to make sure that every person who is a working person in India must get a minimum social security. And that I don't think is satisfied in the Social Security Code.
Thank you so much, sir. Thanks to Saurabh, we got to also deal with a little bit in the Code of Social Security. I believe we have a question by Lovish Kumar as well. Lovish?
Hello, sir. So, under new regime, fixed-term employment proposal has also been welcomed by the industry. Now, they will be able to hire contract workers directly for fixed tenure. So, I have a question that what are the consequences of fixed-term employment on permanent employment?
Yes, you see, the labor movement has always demanded that when you employ somebody, you should be given an appointment letter. And in the appointment letter, normally the terms and conditions of employment are spelled out. What is the wage? When will the wages be paid? What are the social security provisions that you'll be given? How is transport going to be arranged? Will you be entitled to, food in the canteen? These are the matters that can be put into an appointment letter. Under the new appointment letter, along with the appointment letter, it actually becomes a termination letter. So it's a new instrument. When you get your appointment, you're also informed when you will be terminated. That's the meaning of a fixed term contract. The date of your termination is informed. Naturally, employers are extremely happy with this provision. So once you have that kind of a provision, then all workers will be on their pins, and you never know, when you will ever get a chance to come back to a job in that company or in the establishment. So it is actually giving legal sanction to the old doctrine of hire and fire. Hire and fire was condemned across the world in industrial jurisprudence. Now you are bringing it back onto the statute book by providing for it in the Industrial Employment Standing Orders Act. Yes, it's a retrograde step.
Sir, I believe Lovish has a follow-up question as well.
Sure. Welcome.
Over to you, Lovish.
Yeah, sorry, Professor, just quickly, I had a follow-up question to Lovish's question actually, which is about the fixed-term employment and the changes that it brings about to the current structure. You briefly talked about how this is a retrograde step, but one of the biggest disadvantages of this fixed-term employment is that the code doesn't specify what kinds of work would fall under fixed-term employment. Unlike the contract, even the Contract Labor Abolition Act, which was considered to have its own imperfections, it still specified that certain kinds of work, whether they were like perennial in nature or work that was intrinsic to the conduct of business, some sort of work that was supposed to be for permanent employees could not be contracted out to temporary employees. And that was one of the hallmarks of that act. But the current provision for fixed term employment seems to do away with that. So seemingly the need for permanent employment itself is done away with, because now you could employ anyone on like these short term contracts. And the disadvantage with that is, despite the code saying that the fixed term employment will be subject to the same benefits that permanent employment is subject to, if I have a contract that says that I'm going to work for a short period of time, and if I want that contract to be renewed, I'm not going to be asking for more benefits, because I know there's a possibility of my employer canceling my contract. So does this basically, take a huge step back from the achievements we've made with permanent employment?
Yes, I think so. This is the intention is to completely destroy the notion of permanent employment. And that is why I link it back to a prime minister who wants to have self-reliance. How can you have self-reliance if the company is eternally run on the basis of temporary workers? When will the temporary worker come to know the niceties of that particular industry that person is working? So that is a great lacuna. You see, as you rightly pointed out to the Contract Labor Abolition Act, in the old law in that regard, there was the idea of perennial work. Is it work which is essential for the company? Now that has been amended, and the idea of perennial nature of work is removed. In its place, they make a distinction between core work for the industry and non-core work. And on the basis of that, in any case, contract labor, unfortunately, because of a Supreme Court decision, if contract labor is abolished, the contract labor can be sent home. Who wants to go and ask for the abolition of contract labor system if you know that at the end of it, you invite dismissal and you are sent home? We used to ask for contract labor to be abolished so that you can be absorbed as a permanent worker. And this was an opportunity for the legislature to reverse the Supreme Court judgment. When the Supreme Court was studying this aspect, they said, it's not for the Supreme Court to pronounce on this matter, but it is for Parliament to pronounce on the matter. So Parliament should have pronounced on this and said that whenever contract labor is abolished, then they should be made permanent. Anyway, that's a different question. So far as fixed term contract is concerned, it's left to the sweet will of the employer. They can decide how many people should be given a fixed term contract. The idea, you see, after all, commonsensically, if there is a certain type of a job in an industry which is of a permanent nature, it might be, cleaning the toilet. Cleaning the toilet has to be done permanently. It doesn't come to an end after 1 week or 1 month or 1 year. If that is a permanent activity, then why should the workers be rotated? Cover him with an appropriate contract of employment. And the idea of fixed term, it is intended in order to make sure that workers are in permanent state of insecurity. And that anxiety will prevent them from becoming, members of a trade union. It's a very advanced anti-labor practice, which has now been recognized in the statute.
Sir, could you also just briefly touch upon the fourth code on the occupational safety
Yes.
conditions?
Yeah, I think the very interesting thing about this occupational safety code is the very idea that you are now giving the statute the title of occupational safety. And therefore, my first temptation for reflection is the idea of occupational safety at work is a very welcome idea. But please remember that in this country, there are many forms of employment in which the moment you get into that employment, you are exposed to so much of hazardous material. It may be inhaling hazardous material, which will go and settle in your lungs and result in an irreversible condition of different types of lung infection, or the lung becomes morbid, becomes hard. And so pneumoconiosis is a common expression used for that condition. There are many such occupations in India. What does the occupation code do in this respect? It says if that happens, then a notice must be given to the authority. And then the board will, inquire into it. I would say that if you're serious about tackling occupational diseases, identify those occupational diseases which have proved to be fatal in nature. And if you know that a particular type of occupation is fatal in nature, and if you have a minimum technological standard which can prevent such fatality, then the law should say, unless you introduce that level of technology, this employment will not be given. So that is the bogus manner in which occupational safety is sought to be dealt with. It's a misnomer. You shouldn't call this law as occupational safety if your only intention to tackle hazardous conditions of work is to ask the employer to give a notice to some other authority. We know what happens when such notices are given in this country. The next important thing is in relation to hours of work. In the Factories Act is a product of so many years of evolution. It is Dr. B.R. Ambedkar in the central legislature. He is the one who brought about the amendment to introduce the 8 hours of work. And we are all aware that it is ILO Convention number 1, as old as 1919, which introduced the 8-hour work and the 48-hour week as the maximum. The initial draft tried to say that the length of the day will be left to the prescribed by the appropriate government. There was a lot of hue and cry. And I must say, one important change that the government has accepted, one of the very few acceptances which the government has made, and I think that is partly because the ILO chief wrote to the Prime Minister that you are going against the most cardinal principle of the ILO. And so they have now said it will be 8 hours of work. But they are silent about the 48 hours per week. And that still is left, in the area of vagueness. More than that, when it comes to the occupational code, what is very sad is that it ends up repealing 13 statutes. And out of the statutes that are repealed, there is the Interstate Migrant Workers Act. The existing Interstate Migrant Workers Act is a good legislation. It has many provisions which have far-reaching potential for good use, provided it is implemented. Unfortunately, we all know the most invisible part of Indian labor was the migrant laborer till COVID struck. And suddenly the migrant laborer became visible. And as a result of it, there is attention received. The most injurious part, the most harmful part of the Interstate Migrant Workers Act of 1979 is the definition of the word interstate migrant worker. In that definition, there are two conditions attached. One is the worker must be somebody who has been employed through a contractor. And the other is the person must be interstate, must have moved from one state to another. As a result of criticism on the draft, they have partially cured it in order to say that a migrant worker may be somebody who doesn't come into employment or migration through a contractor. But the other part is retained. And the other part is he must move from one state to another. Why should it be so? If you take the state of Karnataka, the maximum movement is from the districts which are always in difficulty, drought-affected diseases, but like Gulbarga or Bidar or all the neighboring North Indian districts. And therefore, people come in search of employment to Bangalore. Are they not migrating? Why should you exclude them? Therefore, one of our suggestions for improving that idea is whoever moves from his ordinary place of residence in search of employment to another place and finds employment there, that person is a migrant laborer. And the migrant laborer must get all the benefit. And if you go to that enactment, yes, the migrant laborer should be given a passbook, that's the language that is used, which will be an identity document in which the wages must be entered. And the Interstate Migrant Workers Act has a schedule. Friends who are interested in this part of labor, please read that schedule. That schedule brings into force 5 important social security legislation, which can then be accessed by the migrant labor. And that includes the ESI and the Provident Fund and more than that. So instead of retaining that legislation as it is, you brought it into the code and you have, diluted the standards so far as migrant labor is concerned. I'm taking only one example for lack of time. They've done the same in respect of BD workers, in respect of mine workers, in respect of transport workers, and so on and so forth. So many sectoral employments which received sectoral legislative protection, that has been done away with. The jurisprudence of labor in India has recognized for more than 7 decades that you must have, on the one hand, general type of legislation which protects everybody, like the Trade Union Act, the Minimum Wages Act, maybe Social Security enactments. In addition to that, a sector which has its own unique problems, the problems of that sector must be tackled differently so that you're responding to sector-specific issues, like that of the migrant labor, like that of the BD workers, like that of the motor vehicle workers, like that of the mine workers. Instead, all that is repealed and a mishmash is brought about, and it's made part of the so-called Occupational Safety Act. And that again is a negative thing. I'm quite sure that when they try it out, they'll realize that they have done some yeoman disservice. And I would predict that you'll have to sooner or later go back to sectoral legislation. I even suggest to friends in the informal sector that the first major agitation that you should conduct in India is for a fifth labor code. And the fifth labor code should be designed in order to address the problems of the informal sector. And that fifth labor code, part A should be general provisions and part B should be sector-specific provisions. So that is the harm that is done by this last piece of legislation.
Thank you so much, sir, to give us a brief on that. Looks like the labor laws, although they were intended for the labor, they have actually just ignored the rights of the laborers while framing this law. Sir, now, due to lack of time, I believe we'll just take one last question from Deeksha. Deeksha, over to you.
Hello, sir. Good evening, and thank you so much for addressing us today. My question is a little more on the side of the sociological and political perspective, in the sense that a common justification that is given for violation of labor rights is that it is for the development of the industry, presenting as though that the labor is not a part of the industry and separate from it. What would be your opinion on this, sir?
Oh, I'm very glad you asked this question, because we can go beyond the letter of the law and think of other relevant factors. Largely just now in India, at the point of time of this unprecedented crisis, there are two kinds of approaches that the best of economists are discussing. And I'm happy to say even those who were advising the Prime Minister, economic advisors to the Prime Minister, even they have now changed their opinion. And what is this cleavage of economic advice? There are two approaches. One is, please revive the demand side of the economy. The other approach is, please encourage the supply side of the economy. Madam Finance Minister of India has been making one concession after another to the supply side of the economy. You announce that there will be so many lakhs of concessions, you'll get a loan from the banks, and on and on. And what is the result of all this? We have not seen the economy growing. We have not seen the ability of industry to go back into production. Instead, the other school of economists, they are pointing out that if you want to revive this economy, please make sure that ordinary people, those who live at the bottom of the pyramid, they must have money in their hands. And so in order to make money available to them, you must make sure that wages are paid to them properly. If necessary, advances should be paid. When you give a loan to these medium and small scale industry, a condition should be that from out of that loan, they should pay a minimum wage to the workers to begin with. So that when there is money in the hands of the vast majority of the people, then there is a purchasing capacity. When there is purchasing capacity, then there is demand for industrial production. And that is the only way in which industries can recommence their economic activity and get over the crisis. I must say that in the Western countries, in the so-called developed countries, during the early period of industrialization, employers came forward to encourage trade unions and encourage them to do collective bargaining, so that through that process, the workers would get better wages. When workers got better wages, there would be more demand for what the industry produced. And that cycle of continuous purchasing capacity, demand, and higher production is what made industry is successful in the West. And that period is referred to as the golden age of capitalism. The Indian capitalists don't even know what is in the interest of their own future. They are just blindly anti-labor. They don't seem to have any consideration for those who are living in poverty. And as a result, we are stuck in stagnation, and it will require radical rethinking in order to break away from that. And therefore, many of the criticisms that we make of these codes are actually criticisms which will help national development. It's in the interest of the Indian economy that such measures have to be made.
Thank you so much, sir, for giving us such amazing insights about our new labor laws. It has showed us that nor was the manner in which that these laws were passed peculiar, but also that there are various lacunae in the law itself that that exist without actually caring much about the labor for whom this law was intended. Or it almost sounds like it is all muddled up together without really much thought, and that it requires a lot more mending than just accepting it the way it is. It was truly a privilege to host you today, sir. Thank you so much.
Thank you.
I now invite Sir B.T. Venkatesh to share his concluding remarks. Over to you, sir.
Now, before I start, I have a question too. Professor Babu Mathew, I have a question too. In fact, I cannot stop asking you a question. So we are addressing the good lot of the people who are watching this particular program are persons who think that, the competitiveness of the product, competitiveness of the prices are essential. So therefore, and the opportunity for development comes with the competitiveness in the business. So therefore, the wage is a factor which matters most. So therefore, internationally, it's not a question of our own industries. Good number of industries which would like to move to the developed part of the world, whether it's Asia, Africa, or South America, they look at these places for production basically because the labor is available at a much cheaper price than the developed part of the world. Now, this is the competitiveness which is looked into, and therefore the end industry is working on from that construct. So therefore, people believe because of that kind of competitiveness that the government looks at, we are able to have this kind of development in the business. The development in the industry is concerned, development in the employment factor is concerned. If you were to tinker on that particular aspect, demand a position which is very different, then we would rather lose the consequence. For example, I give you the example of the garment sector. I have been working with the garment sector. In garment sector, it is stated that you insist for higher wages. The moment you insist for higher wages, the brand will move the business from India to Myanmar. It would move the business to Thailand. It will move the business to part of Africa, where they're going to be competitive. So you're going to lose employment if you were to look for a competitive or a better wages. You're looking for a better situation. So now this is one of this thing which is being told. It's not just the local businessmen we talk in terms of, but globally, this is the kind of situation which we have. Be it Toyota manufacturing car here, be it Harley Davidson manufacturing somewhere in Asia. It does not make much difference. Every sector is concerned. They are looking at places where taxes are going to be less, or where the labor costs are going to be less, or production costs are going to be less. That would be a very profit-oriented business, because the entire business is built on profit. That's how it's looked into. So therefore, the developed part of the world has become not competitive. Therefore, none of the vehicles are being manufactured. Even in Japan, has reduced the production, and it produces in Thailand, Indonesia, and India. Now, how do you look from that concept? If you were to look from this argument saying that, yes, there is a demand kind of thing, the demand is from the market construct. When you look from the market construct, you have this challenge of competitiveness that's being put forward as an argument in the business.
Not surprising that when B.T. Venkatesh asks a question, it's not an easy one, but I think it certainly stimulates one's mind and requires us to address that issue to the best of our ability. I'm tempted to relate this to what is called as ease of business, ease of doing business. It's part of the same argument. That's the umbrella framework for extending that argument. Now, if you look at the World Bank's approach to ease of doing business, they actually identified 10 items on the basis of which they evaluate and do a ranking in relation to ease of doing business. What is very, very interesting is none of those ingredients, none of the components out of the 10 that the World Bank uses for ranking relates to labor or to labor conditions or to wages. What an industry wants if they are coming into a country is, can industry start successfully? How much time does it take for them to establish the industry? How long will it take to get the power connection? If there is a dispute, how is that dispute being resolved? Are contracts being honored in this country? What happens when there's a financial crisis? So a whole lot of items which are actually concerned with the businessmen wanting to know, is there the ecology in this country for me to do business? They anyway think that labor in India is cheap. So if it is a little higher or a little lower there, that's not the major consideration in respect of proper industrialization. And to that, I would also say that, of course, where there are labor-intensive industries which are located in different countries, there is the possibility that, as B.T. Venkatesh points out, one country may undercut another country. That is what is referred to, for a long time as race to the bottom. How long will you carry on the race to the bottom? And in order to overcome that, during the period of globalization, the trade union and the workers are not against internationalization, how to build an international labor movement. And the international labor movement will have to address questions in order to make sure that there is a limit to race to the bottom. What are the minimum standards which will have to be internationally observed? What else is the job of organizations like the ILO? Unfortunately, during the period of neoliberalism, even the ILO is limping on and off. So that's a factor. This is one part of it. The other part of it, if you're thinking of countries like India, please note that if you look at the East Asian tigers, East Asian tigers include South Korea, it includes Taiwan, it includes Singapore, it includes, at the earlier stage, it included Japan. So what did those countries do? IMF and others brought a lot of pressure on the East Asian tigers, on South Korea, for example, in order to completely give up their labor rights. But there was a powerful trade union. So as a result of it, the government was forced to sit and negotiate with the trade union. And through tripartite mechanisms, arrive at some minimum standards, which was arrived at through mutual negotiation and understanding. Whereas if you look at Bolivia, unfortunately, by then, Bolivia's trade union movement was already smashed because the mines were privatized. And as a result, there, you see, labor and the government could not protect themselves. And so the IMF was able to, impose a lot of anti-labor conditionalities as part of giving them a loan. So in other words, in India, there is a tremendous need for us to learn from the East Asian tigers. Also because their economic model is a model which is in order to build self-reliance. Why is it that Japan, East Asian tigers, even China today, they did not follow the model of neoliberalism. They applied it with a difference. And while doing so, they took care of their laborers. So as a result of better approach to development and industrialization, free from becoming a appendage of multinational corporations, or free from accepting their ideology. They were able to develop something independently, and that's why they stood out as economies. Stiglitz is the famous example. Stiglitz was an economic advisor to the World Bank, and in spite of it, Stiglitz is the one who says this form of neoliberalism doesn't work. And he quotes the example of East Asia. So when the Prime Minister of India wants self-reliance, then self-reliance cannot be achieved by using forced labor in employment. You can't achieve it through deploying race to the bottom. You will have to make sure that they are given some minimum conditions and respected, and then create the atmosphere in order to make sure that our science and technology leads to self-reliance, so that you become competent to compete with the rest of the world. Thank you, BTV, for this stimulating question.
Yes, sir. And it's one of the major issues which we come across is that this ease of doing business, the industry keeps harking upon it. The middle class keeps harking upon it. Most of us do. We say that ease of doing business is essential for the industry, because we look at that. Because of that, we have made a great progress, great advantages. Economy has developed because of that. We look from that construct. In fact, if we were to look into the larger implications of this particular kind of development, COVID exposed the tragic situation that the workers face in this country, that the race to the bottom, which you were referring to, Professor, was something which has seen the effects of race to the bottom, was seen that the people walking thousands of kilometers to reach home, the kind of misery, the kind of difficulty, the kind of challenges that millions and millions faced because of the invisibility of this particular, what you had mentioned in the beginning of your statement, the invisibility of this working forces come to fore. Having seen that kind of a situation, I feel there is a need that we should look from a perspective which is different. There is a need that we need to think that as citizens, we are also equally responsible. One of the aspects which you were part of this particular series which we are trying to reach, Professor, is that by and large, we don't see these people. For us, employment means a government employment. Employment means a software industry. Employment means something better. Employment means America. So employment, we talk in terms of that earns lots of foreign exchange. Employment means a quality, a product which is a brand which is going to be an amazing product we produce. So when we look from these constructs and these kind of situations, we don't look upon to other aspects which don't feel that other aspects need to complement the process. Therefore, they have to be competitive and lesser wage structures. It's an advantage for the society, because longer run, it is being sold. An idea is sold that in the longer run, there's some have to go through the pain, but in the longer run, everyone is going to be benefited. I don't get to see that happen in a system that we live in. In fact, we have seen this kind of situation in better part of Africa, be it in Nigeria, or be it in even as on this day in South Africa, or the best part of South America, where the companies have taken over the entire structure of the state and its thing. For example, we have been now trying to even sell the railways in India. We are trying to sell the entire coal blocks in India. We've been trying to sell the major establishment, public sector, which were essential. We also look, in fact, it went to even the construct of our own BMTC being told that it does not earn profit. Why should BMTC earn profit? So the question here is that our notions of profit earning has gone to such degrees that today we talk in terms of competitiveness, the ease of business. The terminologies that are employed are certainly not towards the development which is for the people is concerned. I think somewhere, how are we to reach, one of the questions which we always try to look at is how important, how responsible a citizen should be, who is not necessarily the kind of working class worker or the garment worker or the construction labor or someone out, tinker, tailor, welder, whatever it is. One who is not, what should be his role? What should be his thinking? What should be his response to loss like this? See, one of the aspects is that it always depends upon a healthy democracy, a healthy society is a very healthy population, a healthy citizenry, healthy discussion and debate on issues which affect the average citizen of this large citizen of this country. Would like to know from you on this particular aspect, role and responsibility of citizens who are not necessarily in this kind of segment is concerned. Because many times when we talk in terms of labor laws, it's for the labor. So the question is that I am not the labor. It's for the labor. And labor always keep cribbing. Now, this is something which we keep hearing in all the fora. Even the courts many a time, and I had my experience, once a judge told me that Venkatesh, time is not far, where hire and fire will be the way, and your argument of permanent employment has absolutely no relevance at all. Just wait for a few more years. Now you are demanding all these things because there are laws. I am compelled to listen to your argument because there are laws. This is a statement from a judge of an high court. Now, we have situations which is virtually reflect what the judge was talking in terms of what exactly role and responsibility should be it a judge, be it an officer, be it a bureaucrat, be it anyone who is certainly not a kind of wage earner in the frame which we look at, because we have the structured, stratified society that we live in. Just sometimes I want you to explain on this. It would be helpful for the audience to understand what exactly the nature we look at. Many times we look at this. Worker means somebody else, not me. How I am responsible for him too. Why his conditions is necessary, his condition being good is necessary for me. And that's something which we need to have some explanation, very helpful for the audience.
Yeah. Yes, one more challenging question from BTV. I'm tempted to refer back to the early days when the Second World War concluded. We all know that there was extraordinary unity between countries which would not otherwise come together. The United States of America, United Kingdom, and the Soviet Union. 2 capitalist countries and 1 socialist country comes together. Why did they come together? Because they felt that Hitler had gone too far, and using this idea of Aryan superiority, he conducts a war and he wants to take over the whole world, and fascism comes into being. And as a result of fascism, the world experienced unprecedented cruelty and violation of human dignity. And that was such a massacre of humanity that nobody could take it any longer. And hence, in the Second World War, Hitler was defeated. And after that, you see, the hegemony of fascist thinking was broken and a counter-hegemony was built. And the basis of that counter-hegemony was human rights. That now we need to build human rights so that such a calamity does not happen ever again. I use 2 expressions. Fascism tried to introduce its own hegemony. Hegemony is a condition where everybody subscribes to that thinking. And counter-hegemony is the opposite of it. Whenever counter-hegemony begins, it's an uphill task. But by the time fascism was defeated, counter-hegemony became the new hegemony, and human rights thinking flourished and took over the United Nations organization. And we have all those wonderful human rights standards, across the world. Every constitution is inspired by that. But post the collapse of the Soviet Union, the greatest challenge to capitalism also came to an end. And when the challenge to capitalism came to an end, then capitalism felt that it now need not bother. It need be concerned only with maximization of profit. That is why people like Francis Fukuyama wrote The End of History. They were trying to say, now that socialism is collapsed and fascism has collapsed, there will be the continuous rule of the market forces. And that kind of thinking began. And so, therefore, neoliberalism is a completely new era in the world. In India, Manmohan Singh and P.V. Narasimha Rao brought it into force in 1991. And as a result of neoliberalism, a new ideology has been spread. And that is the, blind assumption that privatization is a solution for everything. That if you give complete freedom to the market, it will solve all the problems. But over a period of time, now it is almost one generation since we, succumbed to neoliberalism in India. And what's the outcome of that? We have seen two things which are standing out. One is ever increasing inequality, and on the other hand, ever increasing unemployment. So as a result, people have naturally started to ask, what's the meaning of this neoliberalism? And I think, therefore, the hegemony of neoliberalism, which was prevailing across the world, after the 2008 crisis in the United States of America, they also realized that neoliberalism doesn't have all the solutions. And so now, even in India, that has come to the fore. COVID has aggravated those circumstances. So I think the ground is now once again happening where people will have to search for a new narrative, which is different from the narrative of Washington consensus and neoliberalism. And that process, of course, the educated youth will have to play an important role. And I'm glad that your program is reaching out to those sections. The thinking people will have to play a role along with the toiling people. So there has to be new kinds of alliances. A green alliance is necessary. The old social movements and the new social movements must come together. The new social movement is an environmental movement, is a women's movement, is a feminist movement, is the movement of different social groups. And all these movements must come together. And that kind of a coalition will have to work its way up. And only then can the present hegemony be broken. But I believe that just now, there is a deep fracture in the hegemony established by neoliberalism. And so through those cracks, the counter-hegemony will emerge. Your program is a small contribution towards the building of a counter-hegemony. So many more people will have to join in that process so that we will realize that during the Philadelphia Declaration of the ILO, there was a famous statement that poverty anywhere is a threat to prosperity everywhere. So that is the current condition. It is not poverty anywhere now. It's poverty everywhere. And so under those conditions of inequality and discrimination, I think material conditions for the rethinking has begun. And that will have to, pick up and come together in order to establish a new counter-hegemony and therefore re-establish some of the values of humanism, human dignity, peace, and dignified life. Thank you. Thank you.
Thank you so much, sir, for your time and these really enlightening insights of yours today. It is with that intention that we started these Friday talk shows so that we can be able to reach out to as many people as possible and to be able to start conversations. It was truly a privilege, and even to B.T. Venkatesh sir for the really insightful, challenging questions that you posed. It was amazing. Thank you so much for your time, and thank you, sir.
Thank you. Thank you for this lovely
I would
opportunity.
like to add something, Professor Babu's statement. It was necessary, I feel, that at this point of time, that all the laws that today which are being discussed and debated are the laws which the people of this country have fought for decades.
Yeah.
Sweat, blood, months and years of strikes in Bombay, months and years of strikes in Kolkata, months and years of strikes in Bangalore, any part of India. The industrial part of India has been so much involved in these kind of changes that has happened. All the beneficial laws that we talk in terms of before neoliberalization of the process, the way the courts had came in to define the whole construct of industry, industrial relations, worker, you name every aspect of it, has been an extraordinary exercise by the people of India, be it the judiciary, be it the politician, be it legislators, be it the movements, be it the trade unionists, all of us. Great success has seen. We have been we have changed the whole construct. In fact, the kind of laws that has been brought in India have been utilized in best part of the world, even the developed part of the world, as a wonderful way to look at the worker industrial relations are concerned. Now, from that situation to the present situation, where today we are looking at as times as old as a time when we had no law at all. I think, in fact, sometimes it appears quite gloomy when we hear to look into these conditions of, in the name of ease of doing business, are we sacrificing the worker? In the name of our short-term profit, are we sacrificing lives? In the time of short-term profit, are we denigrating an entire section, a large section of society into impossible living conditions, thereby destroying the fabric of the nation itself? I think these are the very serious questions that we need to look and ponder. Healthy society is a society where people are healthy, economically healthy, socially healthy, healthy in their education so that they can contribute better. A society which has all these factors is a society which was the aspiration of the fathers of this nation. In fact, when we had this constitution, if we were to listen to what Ambedkar said, that it's not that the laws make, the constitution makes it, it's the people who make a nation. And there's an old Telugu poem written in 1910 by Gurujada Parao called Deshabhakti. In that, he makes a statement, Deshamante matti kado, Deshamante manushaloy. Nation means not the geographical region. It does not mean the boundaries or the borders or the land. It means the people. It means the people who populate that region. That's nation. And for that, all of us need to be together, and health of everyone, we have seen in COVID, is health of everyone. Anyone who's there need to be healthier. Today, COVID shown that, in fact, unfortunately, virus tells us that you need to learn from that. Your neighbor need to be healthy. Everyone need to be healthy. Everyone need to be good condition. Everyone need to have good nutrition, because only when people are healthy that we can expect health. I think that kind of a message, as Professor Babu said, with the Philadelphia Convention, the statement, the poverty today is everywhere. I think this is the time that we should look at a society, as a healthy society. What should be our challenges? I think I leave this as a question to you to ponder and think and come forward, say that, this will not be accepted. There's a need that these kind of laws need to be better debated, discussed before they are made into laws which impact the lives of millions of the people in this country. We're a small country. If we talk in terms of 5% of the population, it means the population of UK, the entire population of UK. If we talk in terms of 8% of the population, it means another larger country out there. If you say 20% of the population, it's as much as USA. That's the kind of numbers we talk in terms of. So that's the kind of impact that's going to have on us. I think we should be thinking in these lines every moment, that labor laws affect us too. Not so much as that it cuts into my wages or income, but it impacts my life. It impacts our society's life. A healthy society, we will have healthy situation. I think even for your own selfishness, you need to ensure that there is a healthy society and healthy economy and a healthy working class. Thank you.
Thank you. Thank you very much.
Thank you so much, sir. Thank you.